I appear with Mr. Clark, Mr. Rowbottom and Mr. Matur for the third and fourth appellants. Mr. Mallin's King's Counsel, Mr. Samuels, Ms. Mara, Ms. Hudson, Ms. Samuels and Mr. Buchanan appear for the first appellant. Mr. Hislop, King's Counsel, Mr. Buchanan, Ms. LaBeach appear for the second appellant. Mr. Knox, King's Counsel, and Mr. Turnbull appear for the Crown. My lords and my lady, I'm going to make about 3 hours worth of submissions. There may be some additional, well, there will be, I suspect, some additional remarks from, in particular, Mr. Buchanan, but because I think we're allocated 3 hours 15, I think, but I will cover almost everything, essentially.
We should make it clear we've read the written arguments, which are very full.
Yes.
There's no need to repeat all of that. The points at the end of the day seem to us to be fairly short points, although the point about whether the jury should have been discharged is raises some important issues.
Well, yes, and they're just on that point about the jury, and I'll try and, given those remarks, try and perhaps spend more time on the jury. Given those points about the points you've just raised, can I just draw attention to the court first to some material that was served overnight?
Yes, we've got all that.
The Crown. Yeah, so the position now seems to be, I mean, it's a little unfortunate it was overnight, given this, for example, was left unresolved in the Statement of Facts and Issues. But the position now appears to be that it's accepted, I think, that Mr. Kane, who was the juror in question, was convicted of perverting the course of justice in relation to this matter.
Forgive me, attempting to pervert the course.
Oh, sorry, attempting to pervert the course of justice, yes. However, the key point is that was in relation to the bribery attempt. So there was a conviction in relation to the bribery.
Yeah.
One thing that you may not have picked up, which may be of some relevance given some of the case law, is that the indictment, or the charge sheet rather, I think more accurately, that has been provided, makes it clear that Mr. Kane's behaviour was alleged to go back as far as the 18th of November 2013.
Well, we're not here to investigate the facts.
Well, my lord, the only reason I make that point is this. One of the points which I accept is not to do with I accept the point my lord's put to me, but one of the points we make is that some of the case law, Putnam in particular, makes it clear that one of the concerns that arises in relation to juries is that, to use the language of that case, the longer the poison has been circulating, the harder it is to effectively produce a fair trial. And the point that we would make, and that's sort of in one sense emphasised by the indictment, and that's why I drew attention to it, is that, of course, given the questioning in this case by the judge of the jury, it was unclear, at the very least, how long the poison had been circulating. The other reason that's also relevant is it raises questions about why jurors who perhaps have been affected by the poison didn't ask earlier, didn't rather raise the matter earlier with the court. And that's also an issue that is identified in Putnam as being a potential issue. And so, my lord, the only reason I draw attention to it is not to suggest that the court's findings about how long this attempt was ongoing, but to emphasise the point that it's actually on the material, and in particular the questions asked by the judge, it's very difficult to know how long this problem had been circulating within the jury. So that's why I drew attention to it. Well, given the remarks of my lord a moment ago, my plan had been to deal with the admissibility of JS2 and the breach of the charter first, and then go on to the jury issue. But I can take things out of order if that would assist.
It's entirely for you. Sorry.
Well, in terms of the Charter, it's important to recognise, and JS2, the exhibit that we obtained in breach of the Charter, it's important to recognise two things that are not in dispute. The first is there is no dispute as we see it. See the respondent's statement of case, paragraph 20, subparagraph 1, which is electronic bundles 6216, that there was a breach of section 16 of the relevant Jamaican statute. There is a dispute about the exact nature of that breach. In particular, the Crown's concession essentially is simply that Corporal Brown was not authorised to request the documents. We would point to the fact that the Court of Appeal went further, see page 5827 of the electronic bundle, and found that, in fact, there were three faults, which were Corporal Brown wasn't authorised, he wasn't to request the data, he wasn't authorised to receive the data, and notice wasn't not issued. But in many respects, that doesn't really matter. The key point here is there clearly was a breach of Jamaican law. The second point, possibly more importantly, which is also accepted in the Crown's case, is that the defence had argued before the trial judge that JS2 was inadmissible, and in particular they argued 2 points which are reflected, we would submit, in our arguments. Firstly, reliance was placed on the Charter. One sees that at paragraph 24 of the Crown's case, that acceptance. And secondly, it was expressly argued, see paragraph 23.2 of the respondent's case, that FIPS, which is the leading authority that was applied by the Court of Appeal, was not necessarily determinative because it had been decided before the Charter. And so it is clear that at Supreme Court level, the arguments were about whether JS2 should be admitted in light of compliance with, non-compliance rather, with the Charter. That explains why in our submission the Court of Appeal clearly chose a question. They had argument obviously about what question should be forwarded to the board. They had argument about the question and concluded one that was essentially linked to the breach of the Charter.
Sorry, Mr. Southey, it may be me being very slow, but you started that by saying there was no dispute that. I'm just struggling to see what there was no dispute about on this point.
The breach of the Charter was being argued. Yeah. Yes. Sorry, I should have been. Yes, I'm sure that was me. Point I was making that there was no dispute about. There was no dispute that at trial level it was argued that because there'd been a breach of the Charter, the phone should be excluded.
Yeah. Okay. Thank you.
Or the phone evidence. JS2 is perhaps a better way of describing it.
Just while you mention JS2, what's the relationship between JS2 and Exhibit 14C? Can you just explain that to me? So, is JS2 covering all the relevant technological evidence, including the BlackBerry belonging to Mr. Palmer, or is it not?
No, JS2 is the material that was obtained from Digicel, which is why the issue of the compliance with the relevant legislation was an issue. 14C was the download from, I think it was the BlackBerry, was it? Yes, it's from the BlackBerry. So 14C was a separate. It was effectively a separate issue.
So we're not dealing with.
We're not dealing. No, exactly.
We're dealing simply with JS2. And just in outline summary, what did that include? There were the conversations, as I understand it, between Sorry.
Sorry, no. Sorry, that was rude of me, sorry.
Well, I was going to say the conversations between the deceased and his girlfriend, is that right? While travelling, allegedly?
Yes.
Yeah, and then does it also include Mr. Wee, evidence in relation to what he...
You mean Mr.
Chow?
Chow.
Sorry, yes, there is evidence, there was communication in relation to Mr. Chow. Possibly the best summary, which is what I was going to... I mean, obviously, in one sense, one of the reasons for not focusing on what it concerns is that in relation to the jury issues, the Crown's case is the matter was overwhelming in light of JS2, which demonstrates in one sense its significance. The summary, though, of what it included is paragraph 155 of the Court of Appeal's judgment.
Thank you.
Page, sorry, yes, 5837.
Thank you.
It's also just worth noting paragraph 24 of the Court of Appeal's judgment, which notes how that also summarises the evidence and notes in particular, it goes to the point my Lord just raised about Mr. Chow, and that's 5783, paragraph 24, and that's relevant because it notes that this material was relied on to show constant communication between the defendants and Mr. Chow. It also was then the basis, there was a certain amount of cell site analysis, and it was the basis of that. And you see that in the trial judge's summing up at 5071, paragraph 13. Not paragraph 13, line 13. And just to put it in context, one of the reasons why it was also relevant was this was a case where the live evidence, essentially, in relation to Mr. Chow, had real question marks against it. And that's, in one sense, demonstrated by the acquittal of Mr. Williams, who was a defendant the Crown's case entirely consisted of Mr. Chow in that case. So where Mr. Chow was the sole evidence, there was an acquittal, essentially.
So, just so I'm absolutely clear, so the evidence in relation to what Mr. Palmer had on his BlackBerry is not part of what we're now concerned with?
No.
What about the video in relation to Mr. Chow?
Can I just double check on that with my team? But I don't think that's within the agreement. I don't think that's within JS.
That was in 14C, as I understand it.
But in my submission, that would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
I think, my lords, I'm bound to accept that we don't know, of course, but obviously what concerned the judge is, I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
But what I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. And they are prepared...
How can you be sure? You just don't know. You don't know.
Well, Well, my lady, well, funny enough, we do know in one sense, because it was a 10-1 verdict, and we know from evidence acquired afterwards that you-know-who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funnily enough, the defence afterwards.
Yes, but if there's a... Well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If the jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have, who knows, it could have inclined them to dig their heels in and prejudice them against the defendants.
My Lord, I agree. That, of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten juror. Does that of itself mean the verdict cannot stand? And can I give you an example where I submit it is not of itself a sufficient reason? Supposing what happens is this. A jury comes in with, let's say, a 10-1 verdict. The one has been bribed, but the one has not revealed that to anyone else. It all comes out after the trial. Can the defendant come along after and say, oh, dear, there was a rotten juror on that, he didn't tell anyone about it, but nonetheless the verdict must be set aside because there was just one, as it were, there was one person who wasn't performing his duty, qua juror. My submission would be that would receive short shrift from the appellate court. It would say, well, the rotten juror didn't speak to anyone, he didn't obey his duty, he did come in with a not guilty verdict because he'd been bribed, but on the other hand, that made no difference whatsoever to the 10 who did come in with a guilty verdict. We know it didn't, because he didn't even mention it. Now, in those circumstances, I submit the verdict would stand. And I simply give that as an example as to why what you might call the pure point, there have to be 11 good jurors, even when there's a 10-1 verdict and the 10 are good. There have to be 11, and the whole thing falls to pieces. Cannot be right. And I submit that, in the example I've given, that would give rise to very considerable public concern.
But the trouble is, we don't know.
I've got to add to that.
We're not supposed to know.
Well, I know we're not.
Who's saying what in the jury room? So you can never. So the hypothetical you've given can never arise in reality.
Well, my Lord, I hesitate to disagree, but I would submit it could arise, and indeed, in this case, we do know precisely what happened. Yeah. I mean, supposing Livingston came, for whatever reason, supposing he had not mentioned any of this to the jurors, but afterwards it came out that he had actually received bribes and was convicted. But let's just say, or he had received bribes from one of the defendants. So it's not on all fours, but I'm simply at the moment on the point, do there have to be 11 good jurors, full stop? And if there's one bad juror, the whole thing falls away. I submit that's not right. The other question is the different question entirely, namely, what about the juror, the 10 good jurors, saying to themselves, well, you know, obviously, they're all bent, these people, and so I'm going to hold. It's a sort of little bit of prejudicial information which they're holding against the four appellants. That's the question. Now, my respectful submission on that is, as well the second part of the question. Is this. The question is, was the judge bound to assume, in all the circumstances, that whatever directions he had given, or could give, was he bound to assume that the taint, if I can put it that way, of the bribing juror was never going to leave the minds of the 10 good jurors, such that, maybe even unconsciously, they would hold this against the accused?
But isn't that the wrong way round? Doesn't he have to be sure that there isn't that risk, rather than the way you've put it?
Well,
he has to be sure that there won't be, that justice will be done,
yes,
rather than the other way around.
My lady?
I'm trying to...
Yes, I'm bound to accept that. I maybe there are too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants. Yeah. That's the question. And in my submission, it's a question of fact to an extent, but on the facts, I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively